Hi, everyone. I'm Claudia Diamond. I'm the Assistant Dean for Writing and Advocacy Support at the law school. It's a pleasure to meet you, even though it's remotely. Normally, I do a presentation in July to our incoming 1Ls, and we have a lot of fun in the moot courtroom. And unfortunately, I wasn't able to do that this year. So I'm hoping that the next 30 minutes will give you a little taste of what we might have done in July and also give you an opportunity to meet me. As way of background, I'm actually a 1995 graduate from the law school. Prior to joining UB 10 years ago, I was a clerk on both the federal and state benches. I worked in private practice for a while. And I also worked for the Attorney General's office for a few years. So I've done a number of things before I came into academia. So anyway, let's get started. What I'm hoping to do today in the next 25 to 30 minutes is talk to you a little bit about understanding the roles and the structures of the courts that you're going to have opportunities to get to know as a law student here in Maryland. So specifically, we're going to focus on state court structure and federal court structure and how the interplay of those two courts sometimes can be an issue as you begin your legal studies. One thing to keep in mind in doing this lecture is that UB takes a lot of pride on knowing that our students really know the roles and structures of the Maryland state courts. It's not unheard of for a judge to call me and tell me that a UB student was able to obtain a clerkship or an internship in part because of their knowledge of how the state courts work. And we'll talk about that a little bit more as we get going. All right, so let's start with this slide. Students who know me will often are surprised to find out that I'm actually the proud mom of one daughter, but I also have 5 cats. And I'm telling you that because you're going to then remember that I'm the dean who's the cat lady, and hopefully that will lead you to remember that we talked about court structure and a little bit about legal citation today. I'm putting up this screen in addition to just take a moment to acknowledge as you begin your law school career that there is no penalty for asking questions, especially now with us being in a remote pandemic environment. More than ever, it's going to be so important for you to look for resources to help you answer questions as they come up during your law school career. So there are no penalties. Now's the time to get over any mindset that I have to know it all. You won't, believe me. And as we'll talk as we go at the very end of our lecture, there's so many resources here at the law school to help you be a successful law student. I am just one of many, but you'll see I have my email right here for you in case you need it. All right, so let's get started. If we had met in July, we would have actually read a case called Hong versus Marriott Corps. And if you have a chance, you should look it up. It's actually a pretty funny case. It's an opinion written by Judge Frederick Smolkin. Judge Smolkin actually teaches at the law school. He teaches evidence, so you may have an opportunity to take a class with him at some point. This case, students often find is very humorous because it involves a case of a woman who sued Marriott Corps, which owns Roy Rogers. Who knew, right? But she sued Roy Rogers in connection with biting into a piece of fried chicken at one of their restaurants and thinking that she had bitten into a worm. And as a result, she brought damages for the psychological distress that she was experiencing. And Judge Smolkin writes a very funny opinion regarding an issue of summary judgment. We won't be covering that today, but what we will be covering is this little thing around the arrow, which is the D Maryland. But before we do that, let me just take a moment and acknowledge that Hong versus Marriott Corps, what I have written here, is legal citation using the rules of the Blue Book. And you'll get very familiar with the Blue Book in your ILS classes, and in the spring with me, again, with our ITA Introduction to Advocacy class that we do in the spring. I just wanted to bring attention to you, even though we're not going to spend a lot of time on citation, just to acknowledge that when I see Hong versus Marriott Court, as a lawyer, I immediately am making a lot of conclusions about this legal citation that helps me if I had to actually use this case to advocate on behalf of a client. Well, first of all, let me just bring to your attention the legal citation regarding 656 F sub 445. 656 refers to the volume where this case could be found. In the old days, when we had the books, I have a picture down below. Each book on the spine has a number on it. That tells me the volume where that book where that opinion could be found. So in this case, the 656 volume on page 445. And the F sub tells me as the lawyer that this actually is a trial court, a federal trial court. And that has meaning to me because, as I'll explain later on, our trial courts are not the final decision makers. You already know that from civics and government classes, that the highest court, the Supreme Court, is obviously the court that is the final decider on matters. As you may know, going into law school and just by being a citizen, that law is made on the basis of precedent. We look to see how other cases were decided in deciding new legal issues before the court. And so you'll learn as you proceed with your ILS classes and your research classes that there are rules regarding how we order legal authority to support our arguments. Is something binding on us as we make an argument, or is it just persuasive? Is it mandatory authority, or what we call primary authority, or is it secondary authority? So there's a lot that we take from legal citation that informs us as lawyers, even though just in short form, legal citation is, in fact, a short form reference to a particular case. All right, that was a long-winded way to get back to the D, Maryland, and that refers to the District of Maryland. And that tells me, as a lawyer, that this is a federal case. The District of Maryland decided in 1987. So let's take a look at what that court looks like. Here's a District Court of Maryland. Maybe some of you recognize this court. Normally, when I bring this picture up on the screen in our large group lecture over the summer, students chuckle because this doesn't look like a federal court. And the answer is it's not. So here's our first lesson today. Maryland has a federal district court. It's called the United States District Court for the District of Maryland. It is a federal trial court where the judges hear evidence and the juries decide cases. Sometimes the judges do too, but it's a trial court. This court is also a district court of Maryland, but not the United States District Court of Maryland, just the District Court of Maryland. And I like to tell students that this court is the Judge Judy Court of Maryland. You may have already had exposure to this court. In fact, most Maryland citizens, if they have any interaction with a particular court, it most likely is going to be this court. Why? Well, if you've ever wanted to contest a speeding ticket, you would go to the district court. This court hears misdemeanor criminal matters. If you decide to plead for a jury trial, you can no longer be in this court. This court is also the court where landlord-tenant issues get decided. It's obviously very busy right now, or soon to be busy, because there's a whole concern about people facing eviction. In addition, the district court also can resolve, but it does not have what we call exclusive jurisdiction on matters involving disputes between $5,000 and $30,000. So if I have a contract action involving $22,000 worth of damages that I think a defendant owes me, I can bring my case in the District Court of Maryland. However, as I'll mention later on, it actually has dual jurisdiction with another court, which is actually the trial courts of Maryland. So the District Court of Maryland, this is not our federal court, but I do want to let you know that this court, and there are many of them, I've only got one picture up here, but there are many of them around the state. Again, the Judge Judy courts, the People's Court, these courts were created in the 1960s by the Maryland legislature in response to the increase of litigation in the 60s and 70s and so on and so forth. And so they're spread out. There's, I think in Baltimore City alone, there's 4 or 5 district courts to handle the people's everyday business, okay? So let's then take a look at what the federal district court is. On the left is the United States District Court of Maryland. Judge Smolkin, who wrote the opinion in Hong, this is where he had his chambers. Again, these are the U.S. District Court of Maryland is a trial court. It's a court of what we call original jurisdiction. And cases typically that are on the federal level begin in the U.S. District Court of Maryland. Now, not to confuse you anymore, but believe it or not, there's a northern division and a southern division. The northern division is right here on the left-hand side. This courthouse is on Lombard, it's between Lombard and Pratt, and right near Cathedral Street, sort of adjacent to the Mount Royal Arena, if that gives you any sense of where it might be. This court, then there's a southern division, which is actually down in Greenbelt, Maryland. So the judges, because just again, the increase of litigation, there was a need for another federal district court house. So the Greenbelt division was created to provide some relief to the judges in this court. All right, now notice here, I've got parallel to the U.S. District Court, the Circuit Court of Maryland. Now the Circuit Court of Maryland is is the original trial court of Maryland. So if I open up the Maryland Constitution, I see a reference by the framers of that Constitution to create a court of original jurisdiction, and they place one in each jurisdiction that exists in the state of Maryland. How many of you know how many jurisdictions we have? Well, I'll give it away to you because I can never remember. If you notice here on the right-hand side, I have the Circuit Court for Baltimore City, and then another Circuit Court for the 23 other jurisdictions making up the 23 counties. So there are 24 in original Circuit Courts. If you live in the state of Maryland outside of Baltimore City, if you go to Towson, for example, you'll see the Towson Baltimore County Circuit Court there. Almost every jurisdiction has a lovely town square, and some of the courts are just beautiful, the old buildings, and of course that's where the court was in a particular jurisdiction. So these are courts of original jurisdiction, the Circuit Court for Baltimore City or for any other county, and they're parallel with the federal district court. Again, why most litigation will originate in the circuit court or the federal district court, and these are courts that are specified in the Constitution, Maryland Constitution and the United States Constitution. But let me just make a couple of other points here. Federal District Court for the District of Maryland rarely has published decisions. Same thing with the Circuit Court for Baltimore City. Although we started off our lecture, if you might remember, we talked about a federal district court, Judge Smolkin, deciding the Hong versus Marriott court case. That's an exception to my point that rarely are decisions published from these courts. Why? Because they're not binding. We have to get up to the appellate level before we get binding precedent. But they can be very helpful sometimes in articulating arguments or explaining what the rules of law are on a particular matter. So don't always discount access to a trial court's opinion, right? Again, or in addition, let me make this point. Federal District Court for the District of Maryland, what kind of cases do they hear? Because I've made a point now of saying both courts are of original jurisdiction. On the federal district court for District of Maryland, you're going to typically see cases there where the parties have disputes regarding federal statutes or a provision of the United States Constitution, if there's a dispute about a treaty, and then something called diversity. And that's where we have individuals or parties, it can be a corporation, from different states who use the federal district court to resolve their dispute. Now, you will spend a long time in civil procedure covering diversity jurisdiction. You don't need to worry about it here. I just want you to be aware that the federal district court, court of original trial jurisdiction, these are the kinds of cases that they might hear. Even in diversity, believe it or not, sometimes they deal with state law because they're resolving a state law issue, but because of diverse parties, diverse citizenship of the parties, the federal court is hearing it. So it can get a little complicated. On the circuit court, usually it's very hard to find published decisions but you do sometimes find online with the legal research platforms, Westlaw or LexisNexis, you'll see reference from a trial court opinion, but it's not typical. And then I also want to make a point, because this is great for you guys as you start thinking about what your legal career might be like. But we take a lot of pride at UB that we have many alums who make up the bench in Maryland. And so it's a great opportunity to do some networking and find opportunities to extern with a judge or ultimately clerk for a judge right out of law school for a year or two. So great opportunity. All right, so those are our trial courts level. We know on the Circuit Court for Baltimore City, one court down below is the District Court of Maryland, the Judge Judy Court. Okay. All right. So if I have a dispute against one of you, and I brought it in the Circuit Court for Baltimore City and I lose, what do? Well, I have a right to appeal. I'm sure many of you know that from government or civics class. And where do I go? Well, in Maryland, if I'm appealing from the Circuit Court of Baltimore City or the Circuit Court of another jurisdiction, I'm going to go to the Court of Special Appeals of Maryland. If I'm in the U.S. District Court, I'm going to go to the United States Courts of Appeal for the Fourth Circuit. And there's some pictures of those two courts. I had the opportunity to be in Richmond in January, and the court was beautiful. The Court of Special Appeals of Maryland is actually housed in the same building as the Court of Appeals. This is a picture in Annapolis. So let's talk about a little bit about these courts. All right, Court of Special Appeals on the left-hand side, just like the Fourth Circuit, appeals are what we call appeal of right. A few exceptions, but overwhelmingly, any dispute that's decided in a circuit court or in a United States District Court, the party who loses has the right to seek appeal in the next level of appellate court, so the Fourth Circuit or COSA, right? And that's, I have to tell students who are thinking about clerking to keep that in mind, because if you have an appeal of right, you have a huge workload because people are appealing all the time. And you'll see when we talk about the higher courts, that appeal of right is no longer an automatic entry to the highest courts of the land. So COSA is, we already said, in Annapolis. COSA is that short form reference to the Court of Special Appeals. The Fourth Circuit is in Richmond. Notice how they both have 15 judges. That's actually coincidental. In Maryland, we have what's called 7 judicial circuits. And because, again, of just the surge in litigation over the last, 40 years now, we have 8 at-large judges. I actually have a friend who's on the Court of Special Appeals, and he got on the bench as an at-large judge, but there was another opening on the Eastern Shore, and he didn't want to move down there, so he waited until there was an opening for at-large and got appointed that way. In the Court of Special Appeals, cases are decided typically by 3-judge panels, even though there's 15. Same thing with the Fourth Circuit. You'll notice that I have in parens a Latin term called en banc. En banc just means on occasion, all the judges get in the room and hear a case. Very rare in the Court of Special Appeals. In fact, I I can't even tell you of a time in the last 10 years where the court has sat en banc, right? But it can happen. In the Fourth Circuit, we have 15 judges, but notice how it's representing various states: Maryland, Virginia, West Virginia, South Carolina, North Carolina. So the Fourth Circuit covers all those states, but Maryland has 3 judges on the Fourth Circuit who are appointed from our states, who help decide cases. But you're not necessarily guaranteed that you're going to have those judges when you appeal. You could have any of the 15. Notice one other point I want to make. On the left-hand side, you'll see I have a case, a legal citation, Marzola versus Call. And I have it cited 3 different ways. See, take a moment and see if you can notice the differences, right? And then on the right-hand side, I have the Fourth Circuit, and I have only 1 legal citation. And I want to bring this to your attention because it's just a good thing to be thinking about as you start your ILS classes and legal citation. In Maryland, we have different ways we cite cases. The Maryland app in Marzola versus Call is actually a green book. In the old days, it was a green book. I think they still publish it. Green spine, and the 135 you already know is the volume, and the 663 is the page. The MD app refers to what we call a reporter, and Maryland app is a state reporter. It's state specific. It's a Maryland reporter. The 763 A second is another reporter. The A second stands for Atlantic Second, 1217. Now, if I go to an Atlantic Second reporter and open it up randomly, I'm going to find cases not only from Maryland, but from what we call the Atlantic region. So that might include Pennsylvania, Delaware. I think it includes West Virginia, but don't quote me on that, right? In the old days in the library, if I was working outside the state of Maryland, I might have access to an Atlantic reporter, and in that reporter, I could find the Maryland case. Or if I was lucky enough to be working in a Maryland firm, or actually I work for Maryland judges, it was not uncommon for the judge to have right behind him the reporters, the state reporters. And if we were referring to a case, he would say, well, what's the site? And I would say 135 Maryland app, and he would turn behind him and grab the book and open up to 663. So, okay, well, what does this all mean? Well, you'll notice in that first legal citation reference to Maryland app as well as the A second, we are doing what's called parallel citation. The goal of anybody who's litigating in front of a court is to make the judge's job easy. And we don't always know, back in the old days, what books were in a particular room for a particular judge. So it was very common to do parallel citation, a reference to both the state reporter as well as the regional reporter. And that applies to any state, right? However, with the advent of electronic research, that rule has been relaxed a little bit, although you'll notice if you work on a law review journal or have opportunities to do other kind of academic writing, that's still a matter of course. Frankly, if I was writing something for a court, I probably would do parallel citation just because I'm old school and I want to make it as easy as I can for the judge or for the clerk who is reading my work. That being said, the second cite is a reference to using only the Atlantic reporter, and our blue book actually says this is the proper citation if I want to cite this case in a state court other than Maryland. And notice how it says MD Court Spec App. That actually is a blue book rule that you'll learn that tells the court outside of Maryland, say for example, New Jersey, that I'm citing to a Maryland Court of Special Appeals opinion, right? So that you'll see that rule. And then the third version is just the opposite of only referring to the state reporter. Many of my friends who are practicing practicing lawyers and government agencies as well as firms now default to just using the Maryland Reporter Here Maryland app. It will be something that you will ask your employers or the people that you're interning with when you begin to work with them, but you can see here's 3 different ways to cite one case, and they all have merit, right? All right, flip to the other side on the Fourth Circuit, and you'll notice here we only have 1 citation and an error in my citation. So Staten versus United States, 685 F second. Again, the lawyer in me, as soon as I see F second, I know that that's an appellate case. It's the Fourth Circuit is an appellate court. I think we're now actually up to F third. I know we're up to F third. I don't think we're up to F fourth. And then the page. Now the error, I can't let this go. You'll notice that I used a superscript for the TH. This is the old journal, and having worked for so many judges under the Blue Book, we don't do that. But I could not get this PowerPoint to undo the autocorrect. It kept autocorrecting to the TH. So I'm going to leave it and tell you I made an error, and that's what it is. All right. That's done. Appeal of right, Fourth Circuit, Court of Special Appeals. You know where we're going next. We're going to the Supreme Court and the highest court in Maryland, which is the Court of Appeals. You may remember this building from earlier pictures. Again, the Court of Appeals is in Annapolis, just as the Court of Special Appeals. The Supreme Court, of course, is in Washington, D.C. And let's talk about these 2 courts. Oh, well, before we do, there's a picture of our Supremes. By the way, just as a matter of something to put in your head, when we refer to the Supreme Court, individuals that make up the bench, they're referred to as justices. When on Maryland's highest court, we call them judges. I'll leave it there. Hopefully you recognize many of the individuals. I will post this PowerPoint for you, which names everybody on the court if you need to know them. And then here is our Court of Appeals. It's actually had some recent appointments. I had to actually go back and make sure I knew everybody's name. In the middle is Chief Judge Mary Ellen Barbera. She actually taught in the program that I managed in the spring, the Introduction to Advocacy program many, many years ago. And then as a new judge comes on, just as in the Supreme Court, the newest appointment gets seated on the outside. So on the right-hand side, our newest appointment is Jonathan Baran. And on our left-hand side, it's Bria Booth from the Eastern Shore. Notice how there are 7 judges. Each of them represent the 1 judicial district. So Bria Booth replaced Sally Atkins, who stepped down from the bench. Believe it or not, the Maryland Constitution requires that judges step down at the age of 70. We could talk about that another time. But Bria Booth, who lived on the Eastern Shore, then became eligible for Governor Hogan to consider her for application. One other thing I want to say about the Court of Appeals in this picture is sometimes people think the costumes are very funny and the robes that they're wearing, but they date back. There's actually a history behind the judges deciding to wear red robes. And the Court of Appeals also has, and I don't know if it still exists, but at one point it was one of the few courts, if the only court, a highest court in a particular state with an all-women majority. You'll notice here there are 4 women and 3 men, and that was pretty glass shattering when that occurred. When I clerked on this bench, it was all men, all white men. No, one African-American judge, Judge Bell, was wonderful. He became the chief judge, and 1 woman who was recently appointed. And I think at the time she was the 2nd or 3rd woman judge to be appointed, Irma Raker, who's now stepped down. If you have an opportunity, make sure that you go down and see the court conduct oral arguments. You'll notice they have dark paneling in the courthouse, in the actual room. Even though the building was built in the 1970s, what they did was they actually dismantled the original court from the state capitol and put it in the new building. So it has a really nice feel when you walk into into the actual courtroom, as opposed to the building, which looks pretty modern, sort of 1970s modern. They've done some recent upgrades, so it looks a little bit nicer. All right, so those are the 2 pictures. So Going back to our chart here, notice Court of Appeals, use the short form COA is what you'll sometimes see when you reference this court. And just like the Supreme Court, how do we get into this court? Well, we have to do what's called appeal by certiorari. And there are a few exceptions that give you an appeal by right, for example, a death penalty case. But for the most part, parties who are aggrieved, who receive a decision from the Court of Special Appeals or the Fourth Circuit, and there's even a few times where you get to jump the intermediate appellate court and go right into the highest court, you have to usually seek certiorari, which is a petition saying we're bringing a novel or complex issue before you that we would like you to resolve for us, okay? So highest court of the land. We have, again, the citation issue that we talked about earlier with the state court reporters, referenced here by Maryland. No, it's MD. Those are actually yellow or beige books, and the A2 being the regional reporter, compared with the Supreme Court reference here. Now, again, Blue Book, you'll soon find out that before a case from the Supreme Court is published in what we call the U.S. reports, it shows up in 2 other reporters, and there are occasions that you might have to cite to those. But again, that's beyond this lecture for today, and you'll learn that as you begin your law school career as a student. Okay. All right, just to review, on the left-hand side, federal, on the right-hand side, Maryland, you can see the parallel tracks. And notice here, again, we have the circuit court, which is really should be parallel with the district courts on the federal side, and then the district court of Maryland, our Judge Judy court underneath. There's also something called the orphans court, which is just a smaller court that hears issues regarding probate and estates, right? Okay, so to sum up again, I just want to bring back to your attention my email. Law school is can be trying and difficult and stressful, and it's a lot of work. And I really take pride in the fact that UB provides a lot of resources to assist you as you begin your law school career. And I've listed on the left-hand side a few for you to consider. Let me make a plug for the Legal Writing Center. If your professor permits, you have an opportunity to receive some feedback from a peer. We have our legal writing fellows who are upper level students. You also have access to law scholars. These are peer tutors that will be assigned to your various doctrinal classes, and they have weekly sessions. Don't forget about the internet. The internet can often be helpful in explaining a legal concept or a rule or reviewing a case, and seek out upper level students and mentors. People are very supportive of helping people navigate, especially their first year, and especially under the circumstances that we're facing this year. Your professor, they all want to hear from you. Don't be shy, reach out to them. And then finally, I'm here, as are any of the administration and all the deans. I've put my email down below, and I've also added 4 questions just to see, for you to test your knowledge and see if you were able to take away anything that I said today. Please take a moment, answer the questions, and send me an email with your questions and tell me a little bit about yourself. And then what I'd like to do is draw some names and then do something a little special, maybe a virtual happy hour, a cup of coffee, and maybe I'll invite a judge or 2 to join us. So anyway, I do hope that you reach out and get in contact with me as you begin your law school career. We're so happy to have you. And, you know, I'm sorry that we weren't able to do this in person, but I do hope to meet you in person via remotely by Zoom as the semester progresses. All right, so that's it for me, and I think I went over a little bit, but not too much. I've tried to limit myself to 30 minutes. So on that note, good luck, and take care, and it was great meeting you, and I look forward to seeing you in the future.